And that case is from Wyandotte County, case number 129703, in the matter of the marriage of Rachel Hale, appellee, and Scott Hale, appellant. Would the parties please take their positions? And would the parties state their appearances?
Please court, Your Honor, Mark Rohrbaugh on behalf of Scott Hale, appellant. I'm with the law office of Dan Stewart.
Thank you.
Good afternoon, Your Honor. May it please the court. Petitioner appellee Rachel Cooper, formerly Rachel Hale, appears in person and by and through counsel Patrick Johnson of Kansas Legal Services.
Thank you. And Mr. Rohrbaugh, would you like to reserve any time for rebuttal? 5 minutes are granted. And with that, you may come forward and begin.
Please court. Thank you for meeting this afternoon to hear this case. Much like they were arguing in the case before us, I think the standard of review is one of the important elements, and there's disagreement on the briefs of what that standard of review would be, and so I'll spend some of my time with that. But just as a large overview, you know, Mr. Hale and I had a tough couple of months last summer with Judge Albee, where we found a court that was hostile towards not only our arguments, but seemingly to the litigant personally, and made many assumptions about facts that were never in front of her, made many dismissive comments about Mr. Hale, and said things like, that's all fine and dandy. I'm sure that's what he thinks. Congratulating Mrs. Hale and telling her she was sorry, assuming that everything that she alleged had happened was in fact true, when none of those facts were ever before that court. All there were statements of counsel. Mr. Hale was never even present at his own divorce trial. So I come in after the fact, and I've got a simple argument. My argument is due process, procedural due process. Counsel argues that 2 points, and I agree that it's a notice and an opportunity to be heard in a meaningful way. The notice is not the issue. It's the opportunity to be heard in a meaningful way that I believe my client was deprived. He had a power of attorney that made arrangements, attempted to make arrangements. She testified in court that she called the court a week in advance, talked to staff so that Mr. Hale could be there in person, and that she believed that he would be there. When she arrived at the day of the trial and Mr. Hale wasn't there, she was surprised that he wasn't there. Attempted to address the court wouldn't hear it, wouldn't allow her to talk. You're not an attorney.
Let me stop there. Where is that in the record? Because I reviewed that hearing and I did not see anywhere where she attempted to interject or speak upon Mr. Hale's behalf.
Well, I guess I don't have a page site in front of me, and it'd take too long to find to be meaningful to you. But it's my understanding from my recollection that that the power of attorney, Ms. Belk, who's here today, was there. And
I know she testified to that, but at a later hearing, but I didn't see where she was there.
At the trial date?
Correct.
I'm not sure if that part was on the record, Judge. I don't know if that happened as part of the court proceedings or if she stood up either before or after a record was made, and I personally was not there. So the record might be silent as to, on the November trial date, as to exactly what Ms. Belk said to the court that day. But her testimony later, when she was called and sworn in, was that she attempted to address the court and was not allowed to.
Counsel, whose responsibility is it in a civil case, once you've received notice that a hearing is going to occur, and I understand the circumstances here and why Mr. Hale was not present, but isn't it still his responsibility to notify the court or to request a continuance? Is it the court's responsibility? No,
Judge. Here's what I would say to you, and the Supreme Court in Matthews says, every case is different, and we need to take a look at the factors in each case and apply the test in this particular case. And in this particular case, Mr. Hale testified to the judge that he did not want a continuance, that he wanted to go forward, and that he had made requests from the jail to go. a day in
Not
advance.
but not until that
Not
day.
until that day or day in advance. I agree. Not with a lot of advance. And he testified that he had been brought to all his previous criminal trials, and he didn't know why the civil would be different. But he had also had his power of attorney call a week in advance and request it, and she.
But a power of attorney is not an attorney.
No, but you don't need an attorney to call the judge and request that someone be there before their trial to let them know that they want to be there. I don't think that takes an attorney at law to do that. I think you could have your girlfriend, your wife, your next door neighbor, anybody inform the court that the person in custody would like to be there at their trial. And the court should have been made, or in my understanding, was made aware that he was in custody and wanted to participate. And she just simply wouldn't continue it. She could have continued it for 30 minutes and called over to the jail and asked if they could bring him down, because they're literally in the same connected buildings.
That was my question, is where's the jail in relationship to the courthouse?
They're literally connected. They're probably technically two different buildings, but they are connected buildings. And he was housed within yards of where the courtroom was. So this idea that it would have been difficult or expensive or burdensome in order to get the person there does not apply in this case, unlike some others where they were in federal custody in Florida. We didn't have that. We were in the same, functionally the same building where the trial
I want
was.
to hit on two things you just said. First of all, you said your client assumed he was going to be brought over because he'd always been brought over in his criminal cases.
That's what he testified to, correct?
Right. Assuming that's true, number one, this wasn't a criminal case. He made an assumption. He made an assumption that was incorrect. And this wasn't like a pleading that judges are to liberally construe. When he decided to represent himself, the court could give him neither an advantage or disadvantage by proceeding pro se. The law's pretty clear on that. He decided to represent himself and wouldn't, in some respects, the court be giving him an advantage by ensuring that he either had a continuance or was brought over. I mean, isn't that his responsibility?
And I would say to you, Your Honor, if that were the only thing, is that he asked to be brought over the morning of, if that were the only thing he did, their argument would be much stronger. But the fact that he had someone on the outside with freedom ask on his behalf.
And that's where that was going to be my second question. I hear a lot about this power of attorney, and I know his power of attorney testified at the second hearing. But any sort of power of attorney document, I do not see in the record. She says that she called the week previous, but her testimony was, I don't remember who I talked to.
Talked to a woman whose name I did not get.
Right. It's very ambiguous. She said she tried to speak at the actual hearing, but there's nothing in the record that says that other than her testimony. It's all very, at best, it's ambiguous. And so when you say, if that's all they had, if that's all the other side had, they may be onto something. But there was this other individual that was, for lack of a better term, advocating on Mr. Hale's behalf. But quite honestly, I don't see a lot in the record that indicates that.
Well, her sworn testimony under oath in open court says that she did it. And I guess if that's about the best evidence I've got to give you, a sworn testimony, Judge. And it does not have to be. Let me ask this question back to you, Judge. Do the courts have an obligation to protect our rights? And yes, does the court have to go out of their way and spend a lot of time and money to protect someone's rights? It depends on what's at stake, right? In this case, the judge knew the man was in the building in custody, knew that he wasn't there, and was dismissive and did not care and wanted to roll forward with this divorce without any attempt to give him the opportunity to be heard.
Counsel, does the timing play into this at all?
Which timing?
The timing, I understand you went back several months later on Mr. Hale's behalf and asked to reopen the case. And my question, if this were done within 30 days, if the request to reopen it would be done within 30 days, a different standard applies. But after that point, it becomes more difficult, and it looked like Judge Alvey was thinking, well, you're reopening now, basically, as we have an ulterior motive for this determination to attempt to reopen this judgment at this point, instead of just, oh no, I wasn't able I thought that I was going to be able to be there. They went on ahead and went forward. What can I do? Contacting the court as soon as possible after the decree was entered.
Judge, I can't speak to anything before I was there. I got involved with it in the late spring when we filed as first hearing in June. Filed my motion maybe a week or three before that. I don't know exactly, but
but it was over 6 months after the decree had been entered.
I would agree. I would agree. And 6260 talks about a reasonable time. Some have a year limitation, so it's within time for that. And we are talking about a constitutional right, which may be set aside at any time. And I say that the decree itself is void because of a failure of a due process. And I guess someone could speculate about alternative motives, but that certainly wasn't any part of our argument. It certainly wasn't any part of our evidence. We said the man didn't get in. We filed this motion. Now, between the filing of the motion, it wasn't 6 months. But before it was heard, it was in the vicinity of 6 months. And the property was all still there. It was all still capable of being judged. And because the man just wanted to get in and have his day in court, and that was still available to him. So there wasn't any strategic value, unless, like counsel argues, that the idea is to get over the 30-day appealing of the judgment. But he's not appealing the findings in the divorce so much as he's feeling that the decree of divorce itself exists, and the whole thing should be set aside because of the due process violation.
Well, does the fact that your client filed an answer change the standard for the court proceeding without him being present?
I think it does in some extent because the court, this wasn't a complete default where the person had never shown up. The person did file a pro se answer and did say that they had problems with the proposed property settlement. It was, it was not a professionally done answer, but I think it qualifies as an answer. And the court was on notice that this person wished to participate, and the person was out of custody when the answer was filed, and then was in custody by the time of the trial. And so
Do you know how long he remained in custody after the trial?
He's still in custody today, Judge. He's still in pretrial detention today. There's not a trial on his underlying case, so he's still in the Wyandotte County Jail today.
So he's never been released.
Correct. Yeah, it's pretrial detention. No conviction has been had.
Are there any other questions from the panel at this
What's
point?
the underlying charge?
You know what, Judge? I honestly don't know. It's domestic violence of some sort with Mrs. Hale as the alleged victim.
Okay, that's the only thing I saw. I didn't know. All right.
Yeah. But I've never looked because it didn't matter to me. All right, and I see my time's up. I will address some of this standard review that I promised in my rebuttal. Thank you.
We'll look forward to it, counsel. Welcome.
The through line of this particular appeal, I think the court has already keyed in on, and that's namely where the responsibility for Mr. Hale's failure to appear at his divorce trial lies. It's the appellee petitioner's position that Mr. Hale had constitutionally meaningful due process notice and an opportunity to be heard, and he merely did not avail himself or invoke the process that the court laid before him. Before I get into—
Well, counsel, how could he invoke that process if he's been held in custody?
Well, he already had invoked that process by filing an answer. He was notified of the case writ large when he was served with the petition. He filed an answer where he offered a nominal response and objection to his ex-wife's proposed distribution of assets, which I think came from his perhaps conversations with her counsel at the time, because there's no reference to that and what her position was in the pleadings. And by the time he was in custody, he testified at the evidentiary hearing last July that he received notice of the trial date while he was in custody. Litigants
Counsel,
who are in.
what bothers me about this case is that everyone knew what was going on. Everyone knew that Mr. Hale was representing himself, had filed an answer, disputed the outcome. Everyone knew that he was in the Wyandotte County Jail, and the trial went forward.
Yes, and Judge Alvey could have certainly in her discretion looked at those facts and said, this litigant is clearly in custody. I'm going to continue the trial, or I'm going to call the jail. She could have done that, but her refusal or her decision to not do so is not a violation of his due process. He still has.
Why not?
Because he has an obligation to fight for his own interests. If the court were to.
Wait a second. He asked to go, didn't he?
No, the record does not indicate that there are any communications between Mr. Hale and the district court. The record.
I'm not asking about the record is that he asked the jail to take him over there.
I think the record is unclear as to what his communication with the jail staff
So
was.
was it an abuse of discretion for Judge Avey not to have him brought over?
It was not. And the record only reveals, I think,
Why?
that Mr. Hale inquired about the logistics of him being brought over to court on that day. The record, I think, is unclear as to whether the de minimis efforts he took that morning to check up on the status of this case was him requesting to appear from jail staff, or him just inquiring, I have a hearing today, when am I being brought over?
Let's look at the facts kind of in the light most favorable to Mr. Hale. And I'm not saying that that's our standard here, but I am concerned about what an opinion that we would write might look like. And in particular, if what happened was Mr. Hale was in jail, Mr. Hale had a person who had the power of attorney asking on his behalf, calling the court without success, seeking to have him brought over or whatever it was that she was asking for him to do. Either the day before or the morning of, Mr. Hale goes to the jail employees and asks to be transported over. And by transported over, I mean just walked over, and is denied that request. And the court knows that he's in jail and decides to go forward with the hearing. Would our decision essentially be sanctioning the ability of a court, anytime someone is in custody, to enter default judgments against them?
No, it would not. I think it would be consistent with how this court has viewed that situation before. This court has in the past affirmed a district court for even denying the request of a litigant to be brought from jail to be heard on a motion. And that was in Brown v. Maloney back in 1997, 24, Canap 2D 424. It also would be consistent with this court's obligation to dispense justice evenly.
Was that
If the
that case in Maloney, was that for a motion or for a divorce?
It was for a motion. The litigant in that case was in custody. He had filed a motion for an abatement of child support based on the fact that he was in custody. He also had filed a motion to appear. This court remanded the case because the district court judge summarily denied his request to appear. But this court made clear that the district court wasn't under an obligation to necessarily grant that motion. And the distinction here is, in this case, there is no evidence of a request made to the district court by Mr. Hale to appear at his divorce trial. What this court would be doing if it remanded this case based on these facts would be essentially saying that the district court had an obligation to advocate for Mr. Hale, to look at the fact that he's incarcerated, to look at the fact that perhaps he may have a cognizable property interest.
Divesting, potentially 50% of the property that he might have an interest in?
Well, he has pro se litigants are held to all the same standards as practicing attorneys. He had the obligation, if he thought that if he wanted to meaningfully fight for that interest, to ensure that he was present. And he took, at best, de minimis efforts to do
I'm
so.
having a hard time with him being able to attend when he's held in custody. What efforts could he have done? He's got to get the sheriff to take him out.
Yes, and
The court could have easily just asked the sheriff to bring him over for a hearing.
the court could have, but it was not error for the court to refuse to do so. And Judge Al, and
Asked you a minute ago why that wasn't an abuse of discretion, you didn't answer. So why wasn't that an abuse of discretion?
because the court is not obligated to compel parties to attend hearings in a civil proceeding, which is what the district court would be doing if this court were to rule that it had an obligation to carry him over from the jail in absence of any request by him to be produced for that hearing. And the district court, in denying Mr. Hale's motion,
Counsel,
yes,
upon learning, so maybe Judge Alvey at the time didn't know, right? She might not have known, but she knew at the 6260 hearing that he had made that request. Upon learning that information, do you think that it was an abuse of discretion not to at least allow him to have the opportunity to be heard in court?
it may have been, but she provided him, I'm sorry, I want to make sure I understand the question. Upon learning that is the question, would it have been an abuse of discretion for her
Not to
deny him?
reopen and allow for the trial to go forward on the merits?
No, I think it plausibly could have been an abuse of discretion for her to, at that point, summarily deny his request, but Judge Alvey conducted an evidentiary hearing over the objection of Ms. Cooper to ensure that justice was adequately served in this instance, and to hear what arguments and what testimony Mr. Hale could provide the court as to what efforts he took to appear on that day. Initially, we were all here on a 6260 motion alleging not a due process violation. It was not alleged that the decree of divorce was void or a nullity. It was alleged that the failure of the court to produce Mr. Hale for the divorce trial amounted to excusable neglect. And a litigant alleging excusable neglect has an obligation to show what that excusable neglect was. And so I think Judge Alvey very appropriately conducted an evidentiary hearing to ascertain what efforts Mr. Hale may have taken and perhaps what his testimony in court would have been
What do you
that
think?
day.
What efforts would have been enough?
Well, the district court in denying Mr. Hale's motion explained that it would have been as simple as sending a letter through the jail service to the court to be produced. Other than that, I don't know what specific efforts he could have undertaken other than making any attempt to contact the district court. There's, again, no evidence of any communication between Mr. Hale and the district court regarding that
Here's
appearance.
the evidence at the hearing that says there was efforts made timely at that time.
Well, I don't think they were timely, and I still question whether Mr. Hale's testimony about his conversation with jail staff amounted to a request or just an inquiry as to when he was being.
With remanding it back for a hearing to determine the equitable division of the assets of the marriage.
I would say there's a couple of things. Number one, first of all, at the initial hearing, despite the fact that Mr. Hale did not participate, the court still conducted an analysis of the marital estate. There was proffers by Ms. Cooper's counsel at the time, Ms. Ikena, specifically about what the assets of the parties were, what the debts of the parties were. These parties had around $60,000 in debt. That was apportioned. It was not all apportioned to Mr. Hale. Many of the debts were bifurcated between them.
But the house was entirely apportioned to Mrs. Hale.
That's correct. And there has never been an argument.
Were there any assets? There were liabilities that were assessed to Mr. Hale. Were there any assets that were granted to Mr. Hale?
Other than,
I didn't find any.
I didn't find any in the decree specifically.
And that's where they would be, correct?
Certainly. But the bottom line here is it has never been alleged by Mr. Hale that that division of property that's memorialized in the decree of divorce from November 1st of 2024 is anything but a fair, just, and equitable division of the marital estate. Basically, what this court would be doing in remanding would be merely acceding to Mr. Hale's request for the sole purpose of giving him an opportunity to provide whatever evidence years after the fact he feels he was deprived of the right to present at the initial hearing. But there is no evidence as to what any of that, there's nothing in the record to suggest.
Because there was never a hearing. So there was never the ability to have a proffer.
From him at the hearing, yes, but he never, in his motion, he never alleged any facts that he felt the court needed to hear and didn't hear that he could testify about that weren't addressed at the hearing. During his sworn testimony at the evidentiary hearing, he similarly did not provide the court with any information as to what he would have testified about on that day. I don't recall off
The equity in the house.
I'm not sure.
So we don't know whether there was a fair, just, and equitable division of the assets of the marriage, do we?
Based on, I mean, I can make an argument that there was, based on the facts of this case, yes, but the court had the information it had when it heard the proffers of counsel. There's really no evidence as to what Mr. Hale would have brought to that equation if he had successfully appeared that day. The only issue in this case, as appellate petitioner sees it, is a request by Mr. Hale to have his day in court. That is not sufficient in this case to remand. This again came before the court on a 6260 motion. He has not established that he undertook meaningful efforts to appear in court, and there's no basis by which the district court could conclude that it was appropriate to grant him relief from judgment. The district court made findings to that effect, that he had not carried his burden to establish under the case law that his failure to appear was the result of excusable neglect. There was no effort to demonstrate that he had a meritorious defense to the suit, which again, that piece of it is important because we don't know what evidence he would have brought or what defense against the ultimate distribution of assets he would have brought to bear in that hearing. And
other than it wouldn't have been a zeroed sum game.
Correct. And that's an argument he freely could have made. Regarding the final factor that Mr. Hale, the district court found, failed to establish, and this dovetails with some of counsel's arguments regarding the purported hostility of the district court judge. This was a case where there were other equities that the court considered, namely the fact that Ms. Cooper had specifically pled that there had been domestic violence in the relationship. It was in the record that she was a protected person under a protection from abuse order, which also does give her control of that property and excluded Mr. Hale from that property. And I submit that is an equity that the court clearly from its decision considered. And with respect to the presence
on that, and I know that you're trying to sum up, but on that is so Mrs. Hale had equitable control of that property because of those findings and presumptions. But that doesn't mean that she has entire ownership and control of that property, does it?
Prior to the divorce decree, no, she did not. But what the divorce decree gave her, which I think is eminently a reasonable outcome in a divorce case where there are significant allegations of domestic violence, is it gave her safety interest in that home. To reopen this case is not merely going to place Ms. Cooper in a position where she has to relitigate matters, that wouldn't be any sort of prejudice to prevent the court from ruling that way, but it would deprive her of that safety interest, of the safety that she, through litigation, had to obtain for herself after she was victims of Mr. Hale's abuse. And so I submit that based on the other factors the court considered at the trial, the decree represents a fair, just, and equitable distribution of assets, that Mr. Hale did not carry his burden to establish he was entitled on any level to relief from that judgment, and therefore it is requested that this court affirms Judge Alvey's denial of that motion. Thank you.
Thank you. Further questions from the panel? Thank you, counsel. Mr. Orba, I believe you have 5 minutes for rebuttal.
5 minutes, here we go. One of the things, because it's top of mind that council just discussed, was my client inherited the money that was used to buy the house. And that was brought up in the hearings, and that was something Judge Alvey was aware of, at least at the hearings, that there is a time, source, and manner argument that he was not allowed to make. And that's part of, did he have any sort of defenses to bring to the table?
So do you know the value of the house?
I don't know it either.
The equity in the house?
I'm thinking, I thought about 150,000 was the purchase price, but Judge, I'm a poor source of information because I didn't do the trial, and I'm giving you just my. But they had like $60,000 or $90,000 that they put down that he inherited, and that's his major concern in the whole divorce, from my best of my memory.
Is that in the record, counsel?
I don't know those values. I don't know if it is.
So
I don't know that. I don't.
This is a 2024 divorce,
Yes,
and he's been in custody since how long?
since October of 24.
Okay.
Yep. Oh, one of the things that in my very limited time is I couldn't get my client to court either. The power of attorney couldn't get him to court. He couldn't get him to court. I couldn't get him to court. I had to have another hearing set. And there's quite a bit of tension in the courtroom about getting my client to court for the 6260 argument. Standard of review. I believe that it's de novo because we're making a constitutional argument. I did plead 6261 and 6, or excusable neglect, under the idea that he was in custody. He, as my judge on my right pointed out, he didn't do a very good job. He made some bad assumptions on that he would be taken to court and didn't ask in advance, but he did have his outside agent do everything that was in her power to try to get Mr. Hale to court. And I do not abandon the argument under 6260B6, which is the last one down there, which talks about it's more the catch-all, any other reason that might excuse it. And that's been found to be a broad and a liberal definition. And what's my case here? Witt versus Elsley says that justice be done in all the facts, and that includes due process. And this was very much a due process argument. And 6260 and due process are not mutually exclusive. I mean, I can argue due process inside a 6260 motion, and that's what I did. And so I believe that we've made our constitutional argument. We cited our constitutional cases. We asked that the case be remanded and reversed, and that the decree be set aside, and that he be given an opportunity for a trial, whether he goes pro se or not, doesn't matter to me. He just needs his opportunity to be in court, and he did everything reasonable, if not perfect, for a person in his circumstances, locked up in a jail and not receiving an inkling of assistance from the court, who knew the circumstances, who knew he was there, who knew he was not happy with the proposed outcome. And could he have done more after the fact? I think so. I think everybody could do more, but he did far more than the nothing before the fact that Mrs. Hale states. So subject to any more questions, I appreciate it.
Any other questions from the panel? All right, thank you very much. Council, thank you for your argument today. We'll take the matter under advisement